We now take up the National Judicial Appointments Commission Bill 2014. Shri Ravi Shankar Prasad.
सीधा वोटिंग करा लो ना साहब सीधा वोटिंग करा सीधा हाँ ना करा लो साहब चर्चा तो हो गई
You can take it over.
चर्चा तो हो गई सीधी हाँ ना करा लो आप बोल दो
Now,
जावड़ेकर जी बोल
I will allow you. I will allow you. Now, I think, what do you say, half an hour or 1 hour? Half an hour, you agree? Everybody, see, everybody discuss.
सर 22 वोट
No, everybody discuss, everybody know what is it.
Yes.
Half an hour.
यस
Or without discussion. I will allow you. Sit down. I will allow you. What is your suggestion? Minister may give the suggestion.
Sir, very briefly, sir, let me say this, sir.
So you are going to move the bill?
Yes, I am moving the bill.
Okay.
Yeah.
Minister, please move the bill.
Raised an issue. This is the bill which is on the basis of the Constitution 124A.
No,
which
after
is not
his-
in a part of the 124A. The Constitution
After moving,
amended.
after his motion, I will.
I want a ruling from.
I will
that.
give you a ruling.
Yesterday the chair gave an
Yes,
assurance.
I will give the ruling after he moves it. After he moves it, I will give the ruling. Okay.
Sir, I move the bill, sir. And let me explain very shortly, sir. Yesterday I also stated, sir.
Only half an hour for us.
This I have already explained, sir. Under Article 246 of the Constitution, this House has got complete legislative competence to pass any law with regard to List 1. List 1 clearly entries 77 and 78 about the composition, etc. of High Court and also the Supreme Court. The full legislative competence is there, sir. Second, I want to convey to this House that the constitutional amendment bill has been passed. This bill shall be sent to the President only after the requisite state governments, state legislatures have clarified that. And thirdly, once the constitutional amendment bill comes into effect, thereafter the assent shall be taken and thereafter it will be notified in the Gazette. Therefore, all legislative competence is there, sir. I would like that let this House be take up the consideration of the bill. Sir, what is this bill? Very briefly, sir. The bill is very simple. The bill says that in case of Supreme Court judges, the senior most judge shall become the Chief Justice. In case of other judges, apart from the consideration of constitutional eligibility, while promoting the judges from High Court, apart from seniority, ability and merit will also be taken into account. In case of High Court judges, it says the name shall be started by the Chief Justice in consultation with 2 judges and as many other judges as the regulation may decide. The regulation is to be framed by the commission headed by the Chief Justice. Why I had said that? And also eminent lawyer. Sikkim has got 3 judges. Allahabad of Mishra ji has got 100+ judges. So regulation can say, apart from 2 judges, you will also consult 5-10 judges if the number is there. Eminent lawyers also. We can take a view that eminent lawyers from all the classes and communities should also be factored into account by regulations. Then, for my ADMK friends and others, the opinion of the governor and the chief minister must be in writing on the recommendations made by the High Court Collegium. Therefore, governor in the constitutional sense to act on the aid and advice of the chief minister. The commission, National Judicial Commission can also recommend names for a particular High Court. Nominate first. But there also the views of the Chief Justice and the Chief Minister shall be taken in the same manner. And thereafter the Commission shall recommend. 2 things I have to say. If 2 members of the Commission oppose any recommendation, then that recommendation shall not be carried. Sir Mishra ji will very well know that in the judge's case, 9 judges had sat in Supreme Court in 1998. Similarly, if 2 or more members of the collegium dissent, the CJI should not persist with the recommendation. Therefore, if in the collegium 2 members were reluctant to recommend, the CJI was to accept the same principle we have followed. And what I told the other house, sir, one is a dissenter, two are voice of reason that must be respected. Lastly, sir, the President can seek a reconsideration of the recommendations made. And the Collegium has to consider in the same manner as they are on a real issue. Therefore, let me go one by one. The supremacy of the Chief Justice is maintained. There are two judges. The supremacy of the High Court Chief Justice is also maintained, but the consultation is to be wider. The importance of the State Chief Minister is maintained. His or her views is to be taken properly in writing on the nominations made. And thereafter, the views of the Commission is also there. And sir, what is the thinking which I very briefly said in my earlier intervention? Commission इस बात का विचार कर सकता है किसी पर्टिकुलर हाई कोर्ट के बारे में हमारे डाटा बैंक में इतने अच्छे अच्छे शेड्यूल कास्ट के वकीलों का नाम है, ओबीसी के वकीलों का नाम है, हमने मालूम किया अच्छा कर रहे हैं, तो हम नाम भेजते हैं, उन पर भी आप विचार करें, वहां से वो नाम आएगा। तो ये सारी चिंता करने का एक बहुत कोशिश किया गया है। और मैं इस सदन को बताना चाहता हूं कि ये जो हमारा कमीशन बनेगा, इसका सचिवालय खूब मजबूत हो, वहां रिसर्चर्स हो, डाटा बैंक हो, इसकी हम पूरी कोशिश करेंगे। इसलिए जब हम कैबिनेट के सामने गए थे तो हमने ये भी कैबिनेट से आग्रह किया है कि जस्टिस डिपार्टमेंट के इसको और इम्प्रूव करने के लिए और जितने पर्सनल की आवश्यकता हो वो होना चाहिए। तो बेसिकली ये जो पूरा बिल है ये नेशनल जुडिशियल कमीशन के प्रोसीजर के बारे में है, वो कैसे काम करेंगे। दूसरी बात हमें कहनी है, एज आई सेड अर्लियर सर, दिस बिल द पार्लियामेंट हैज गॉट फुल लेजिस्लेटिव कॉम्पिटेंस, but as the law minister, it is my assurance to this house that this bill shall be sent for assent to the President after the constitutional amendment comes into effect, and thereafter shall be notified in the Gazette. Therefore, all the precautions have been taken, and I think, sir, this bill also is after wide consultation. I think the House may in its wisdom would like to pass it. Sir.
Okay, do you want a ruling now? Do you want a ruling?
Now, the thing is, I am not questioning the legislative competency of the parliament to make rules on this appointment of judges. My question is, we are discussing a law which is on the basis of a clause, Article 124A of the Constitution. Now, the Constitution doesn't have that clause, Article 124A. After getting the approval of the ratification of the 50% of State Assembly and getting the assent of President, this 124A should be incorporated with the part of the Constitution. Then my question is, how can we discuss a bill on the basis of an article which doesn't have the Constitution now itself? That's
All right, now I'll read. Now see, the issue raised by Honorable Member Rajiv was raised yesterday by some other honorable members also. And in that case, I am giving my ruling now. Now, the same point was yesterday also raised by some members that the National Judicial Appointment Commission Bill 2014 cannot be taken up in the House for consideration and passing until the Constitution 121st Amendment Bill becomes an act, and it will be unconstitutional to pass both the bills together. That is the point. After going through the records and the past precedents, I am of the opinion that it is a legal issue on which the presiding officers do not give any ruling, and I leave it to the wisdom of the House. Accordingly, when you discuss, you can raise the issue either way, and when the question is put for vote, the House can decide. So it is the decision of the House.